or whatever queries they have or some experience they want to share, please definitely put it on the chat box. We'll take the queries or the feedback as and when we proceed with the session, right? So largely we'll try to focus on some important acts, the interplay with some important acts, but I'll also give you an overview of what other relevant legislations are there. Now, we all know that IBC is an evolving legislation, right? It came in 2016, and from then it has been continuously evolving. Some or other new things come up because it's an economic legislation and it has to fit into the market context, right? It has to fit into the demand and supply, the industry dynamics, the market dynamics, because there are many reasons because of which a company fails. Similarly, you need to have a proper ecosystem for the company to survive and get restructured. So during this exercise, the corporate debtor has to, comply with lot of regulations and acts and rules. Different sectors, different corporate debtors belonging to different sectors will have different applicable legal frameworks. And an RP is duty bound to comply with all those legal circular, I think Jan 2018, which says that RP is mandated to comply with applicable legal framework. You cannot say that IBC started, so we don't have to have board meetings or we don't have to call AGM. You still have to have board meetings, right? If quorum is not there, that is another issue. In many of the CRP companies, directors will not be there. The RP will have to show that he did his effort to, ensure compliances. Similarly, income tax, you will have to file income tax return. So there is a existing interplay already when you're doing the CRP process. You're handling so many laws together. Okay. So the session focuses on these activities plus some major Supreme Court judgments and class judgments on, like Limitation Act. I will also touch upon PMLA Act, maybe some on Surface Act, to show what kind of things are happening, how IBC is evolving. In a lot of cases which we do, we see that, FDs which are kept with banks are appropriated by them during subsistence of moratorium. Assets are freezed by SFIU or Enforcement Directorate. Some assets are even auctioned off by, Enforcement Directorate and the likes, similar authorities. Customs authorities sale of certain goods which are kept with them in a bonded warehouse. So these kind of issues then directly violate my moratorium. They directly clash with my IBC. Okay. So we as an RP then have to take immediate steps to write to those authorities or to file suitable application before NCLT or to approach the designated court if there is a special code under a prevalent legal framework under which these authorities are doing it. RP can even approach there and make a submission that there is ongoing moratorium and this should not be done. So we are faced with such clashes day in and day out to protect the assets of the company. IBC is basically for revival of the company, and I have to ensure going concern of the company. How do I do that if I don't have the assets with me, right? So any compliances, any requirement to deal with any other legal framework apart from IBC is necessary to ensure the revival of the company and to ensure that you align with the spirit and object of IBC. So certain laws which there is a clash or there is a lot of uncertainties which come up and which gets moved to courts, like Companies Act is there, Indian Contract Act is there. So TCS versus Vishal Hussain judgment of Honorable Supreme Court that basically said that courts cannot rewrite contracts. Okay, if there is a contract between the parties have to abide by the contract. Courts cannot come in and rewrite the contract that, okay, why don't you do like this? So like Surface Act, a lot of banks, take recovery and enforcement action under Surface Act. They sell off companies asset even during moratorium. So again, whether Surface overrides or IBC overrides, there are judgments. Then you come on Limitation Act, whether limitation will apply or not. So our slides will also have a story on how this developed because there was a lot of confusion. Some courts said limitation will apply, some said not apply. It went up to Supreme Court, and then even Supreme Court's judgment was misunderstood. Again, some conflicting judgments came. Then Supreme Court had to re-clarify. Okay, so Limitation Act, in very short, it does apply, and Section 18 of the Limitation Act also applies to IBC proceedings, and it applies from 1st 2016. I'll request the participants to be on mute. So Limitation Act does apply. Now we have a section in IBC, section 238A for applicability of Limitation Act. Then we have lot of judgments on PMLA, Prevention of Money Laundering Act. So in PMLA also the authorities have the power. Basically, it is for tracing the money trail of criminally acquired money or a property acquired out of criminally tainted money. So PMLA also has investigations from authority to trace that money trail and to attach all the assets, right? So Enforcement Directorate can provisionally attach and have an absolute attachment of the asset. So there are judgments, some conflicting, some very positive for IBC. In NCLAT, there was a very positive judgment for PMLA, and there is a Delhi High Court judgment which says that RP has to coordinate and assist the PMLA authorities. Although PMLA authorities should hand over the custody of the assets to the RP. So we'll look briefly at how PMLA and IBC works as well. Now, before we start with all that, I just want to touch upon why this interplay with IBC and other legal frameworks come in, and why is it so important, and where all our code, the IBC code, has the provisions which touches upon the other laws, right? As we all know, the preamble of IBC starts with an act to consolidate and amend the laws. So it talks about existing laws, okay, and it very well has accepted that when this code comes into play, there will be clashes with other legislations. There will be challenges that one legislation is overlapping with the other. So the preamble itself says that we will consolidate and amend the laws. And in fact, when this IBC came, because they wanted IBC to function seamlessly, it resulted in repeal of two enactments, which is the Presidential Town Insolvency Act and Provincial Insolvency Act, right? And it also led to amendment in 11 enactments: Indian Partnership Act, Central Excise Act, Income Tax, Customs, Recovery of Debt due to Bank and Financial Institution Act, Finance Act, SURFACE Act, SICA Repeal Act. So all these acts were amended, Companies Act, right? Why were they amended? Because the law knew that for IBC to work seamlessly, we have to make changes in the existing laws which might clash with IBC to make way for IBC. Even the courts time and again pick up any Supreme Court judgment on section 238 of IBC, right? It will always say that IBC came later in time and it is a central legislation and it should be allowed to function. If there is a clash and there is a repugnancy and two laws cannot coexist with each other, then IBC has to override the other laws. Now, if you read section 238 of IBC, it does not claim supremacy of IBC. It nowhere says that IBC is supreme. It says that if there is anything inconsistent with any other law, then IBC will prevail. Now, what we have to check there is the provision of the other act and the provision of IBC is in direct clash or not. We can check Innovative Industries Supreme Court judgment, right? There are many judgments which have come. Customs Authorities judgment is there, which is Mr. Sundaresh Bhatt in ABG Shipyard case, where the courts look at the clash. Can IBC provision function when the other laws provision is also in function? If the PMLA attaches the property, can RP take custody of the assets or not? If PMLA sells the property, how will the RP do the valuation? How will he prepare information memorandum? What will the resolution applicant bid for it? So if there is a direct clash, if there is a direct repugnancy, then the other law has to give way to IBC. So all this is derived from the preamble itself, because the entire intent is to get one umbrella insolvency law to enable timely insolvency resolution of the entities. Now coming forward, now we look at some sections of the IBC which hint at in itself to the other laws and why this interplay is important. Section 2, as you know, it says that the section 2 says IBC applies to any company incorporated under Companies Act or under any previous company law. Again, there's a reference to Companies Act. Then any other company governed by any special act for the time being enforced. Then any LLP incorporated under LLP Act 2008, right? So there is a reference to Companies Act and LLP. Then IBC goes on to define corporate person, meaning a company defined under section 2 subsection 20 of Companies Act 2013 and LLP as defined in clause N of LLP Act. So corporate person is your company and LLP. Then 3 subsection 8 of IBC defines corporate debtor to mean a corporate person who owes a debt to any person. And then come to 3, subsection 23. Person includes an individual, HEF, a company, a partnership, and an LLP. Corporate person includes company and LLP. Person includes HEF, company, partnership, trust, and LLP. Right? Then you come to section 3, subsection 31. It defines security interest also. Means the right, title, or interest or claim to property created in favor of a secured creditor. Then coming to 337, subsection 3, subsection 37. It says words and expression used but not defined in this code, but defined in the Indian Contract Act 1872, Indian Partnership Act 1932, SCRA, Securities Contract Regulation Act 1956, SEBI Act 1992, RDDB Act 1993, LLP Act 2008, Companies Act 2013 shall have the meanings respectively assigned to them in those acts. So whatever is not defined here, but defined in these acts, please refer to those acts. Then section 5 defines adjudicating authority, which is constituted under Companies Act section 408. So the NCLT itself is constituted under some other law, right? It's constituted under Companies Act. Then section 5, subsection 19. In fact, there's a very recent judgment, maybe a week back I read it, where one of the NCLT says that all the resolution applicants are putting reliefs and concessions, but NCLT is empowered to give only those reliefs which it has the powers to give under Companies Act and IBC. Other laws, other acts, NCLT has no jurisdiction, and they will anyways refer it to the respective authorities that go and seek your reliefs there. So the NCLT is constituted under Companies Act. IBC says the jurisdiction with NCLT. So it does make logical sense for NCLT to say that I don't have any power apart from Companies Act or IBC. So whatever reliefs you can ask in these domains, I can give. But if you say waive my income tax, allow my carry forward for 8 years, and some license which does not fall within NCLT powers, revive that license or direct some authority to revive my license or get me electricity connection. All these things might not fall in the jurisdiction of NCLT. There are orders which have allowed everything at one shot also. Okay, but then does NCLT have the jurisdiction to give that? Now, there are also cases where in liquidation as going concern, NCLT has allowed reliefs and concessions, saying that, going concern liquidation is very similar to how IBC resolution plan processes. So similar relief concession should be given for going concern liquidation also. But to what extent can IBC, your relief and concession can be granted? If you look at Chennai bench, if you look at Kolkata bench, they give a tabular format in any resolution plan application. For reliefs and concession, they will put a tabular format, note down all the reliefs, and then they'll say granted, not granted, granted, refer to concerned authorities, granted subject to Ghanshyam Mishra case, which propounded the clean slate theory, right? So now this becomes a moot question. If you read these definitions, again, you get to a logical point that yes, NCLT will have jurisdiction under IBC and Companies Act only. It might not be able to stretch its power beyond them to grant any relief. Then coming on to section 5, subsection 19 defines officer, which for the purpose of the chapters means an officer who is in default as defined in Companies Act or in LLP. Section 5, subsection 23 defines personnel, which includes director, managers, KMPs, designated partners, employees. Now, all these people are appointed under Companies Act. KMPs, directors, they are all appointed under Companies Act. So we need to understand their duties, the director's duties, the independent director's duties, the CS, CFO, all these people's duties under the respective act, which is the Companies Act. Then coming on to section 14, moratorium, right? When you read section 14 carefully, it's a very small section, very useful section, right? This is like one of the core and heart of IBC, right? This section also refers to other legal frameworks. So this says that, on the insolvency commencement date, NCLT shall by order declare moratorium for prohibiting all of the following, namely, first is institution of suits or continuation of pending suits or proceedings against the company, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority. So here it brings into the arbitration angle also. So you cannot have institution of suits, you cannot have continuation of pending suits, and you cannot have proceedings, including execution of any judgment. There are cases which we witness where arbitration award has come in before CARP, but execution petition is happening during CARP. And this section 14.1 subsection A says that even there's a bar on execution of any judgment or decree in any court or arbitration panel. So there's a connect with your Arbitration Act as well. Then clause C, if you read, it says the moratorium bars any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under SURFACE Act. So there's a direct reference to SURFACE Act. In fact, any other legal framework also, nobody can enforce security interest during CARB. Then coming on to section 17, subsection 2, clause E. IRP is vested with the management of the corporate debtor, shall be responsible for complying with requirements under any law for the time being enforced. So the moment you step in as IRP, you first have to understand the legal framework of the company, the regulatory framework of the company, what all is applicable on the company. Okay. And then you have to see what has been already achieved. So what compliances are required, what have been done, what is pending. Then you get the clarity of what all you can do or what is required from you to do during the CRP process. Past non-compliances does not come on your head, but from ICD, from insolvency commencement date, you are supposed to ensure the compliances were applicable framework. Then coming on to section 23, subsection 2, RP shall exercise powers and performs the duties as are vested or conferred on the IRP under the code. So RP continues to carry on the duties which are given to the IRP, taking custody, collating claims, verifying the claims, making a list of creditors, taking information from banks, all these things, RP also has to continue and finish. Then when you do section 29A, there also one of the bars relate to some other acts. So one is if a person is disqualified to act as a director under Companies Act 2013, so he cannot give a resolution plan. So there is also a bar on anybody prohibited by for accessing or trading in the securities market. They cannot come in as a resolution applicant. So these all refer to some other legal framework to link it with IBC. Then section 32A, which was introduced when Bhushan Steel's case was going on. Tata had acquired Bhushan Steel, but after the acquirement, Enforcement Directorate and SFA started attaching the assets. And it was like, why should we even bid and take an asset if after taking it over, somebody else is coming and attaching it? So section 32A was inserted to protect the corporate debtor and the resolution applicant from past non-compliances under any law. So if there is any non-compliances under any act, FEMA, RBI, whatever, and the authorities want to take action, they can only take action against the erring promoters, the earlier promoters, not against the company which has been taken over or the resolution applicant. Then you come to section 60, subsection 6, which says that notwithstanding anything contained in the Limitation Act or in any other law for the time being in force, in computing the period of limitation specified for any suit or application by or against the corporate debtor for which an order of moratorium has been made under this part, the period during which such moratorium is in place shall be excluded. Put it simply, for calculating limitation, you will exclude the moratorium period. Section 233 of the code says, no suit, prosecution, or legal proceeding shall lie against the government or any officer of the government or the chairperson, member, officer, or other employee of the board or an insolvency professional or liquidator for anything which is done or intended to be done in good faith under this code or the regulation made thereunder. So if you do something in good faith, you cannot have, no prosecution can lie against you. Section 238, which is called the overriding provision. So provision of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of any such law. So there was a common misunderstanding on this. It has been cleared to a large extent, right? People thought that section 238 is most supreme, overriding everything and nothing will come in its way. But the section very carefully says, notwithstanding anything inconsistent therewith contained in any other law. So if there are consistent provisions, then there can be harmonious interpretation. There are many judgments which have now clarified and said that, wherever possible, if there can be harmonious interpretation of the code with some other law, you should do that. Only when such interpretation is not possible and there is a direct repugnancy and clash between the provisions of the code and another law, does the code override. Okay. So this section only talks about inconsistencies. Whatever is consistent, whatever can be applied, should be applied. We should not simply have this frame of mind that IBC is supreme. No, IBC is not supreme. IBC has been brought in to achieve a certain objective. For that objective, other laws are amending itself or giving way to IBC in cases where there is a direct clash. That's all, right? Then section 238A was inserted somewhere in 2018, and which says that provisions of Limitation Act 1963 as far as may be shall apply to proceedings before NCLT, NCLAT, DRT or DRAT as the case may be. By 238A, Limitation Act was made applicable to IBC. Now, if you want to check out overriding effect of IBC, so there I've just quoted some cases here. And so these are the cases like innovative industries. This was, I think, the first Honorable Apex Court judgment on IBC, right? Where they said that director does not have locus standi to represent company after CRP has started, where they also spoke about the code, that the code is an exhaustive code in itself. And, other laws have to give way to it. They spoke about section 238 also. Then you had Ghanshyam Mishra and Sons judgment, where it basically said that, any claim which is addressed in a resolution plan gets extinguished and the resolution applicant picks up the company on a clean slate. It cannot happen that he's met with sudden claims even after approval of resolution plan. So clean slate theory was propounded, and also this judgment is used extensively in tax representation. It so happens that after I pick up the asset as a resolution applicant, I file my tax return, I'll be putting the waive off of liability and everything, right? So there might be assessment notices which says that you have written back so much of loan, so you'll have to pay tax on this. So a lot of such representations in response to such notices, we put in this judgment of Ghanshyam Mishra, saying that all claims stand extinguished, and based on NCLT order only, we have written it back. Then coming on to then you have Principal Commissioner says Mohammed Ispat. Here also they spoke about IBC overriding with tax laws. We had Duncan Industries case, Gupta Metallic. So in some cases, you had authorities attaching assets. So in Gupta Metallics, in fact, the court itself had done an auction, and it went to Supreme Court, and they said that you have to cancel this auction because moratorium is there. Omkar Assets versus CCI Infra also relates to similar attachment cases only. All these cases basically spoke about overriding effect of IBC when there is a repugnancy. So what I can do is I'll just come back on the limitation aspect first, and then we'll proceed to take up the other laws as well. Just hold on, I'll share the next slide. Yeah. So now focusing on limitation. See, when IBC came in 2016, they did not mention that, the court did not mention anything about limitation. Section 238A was brought in much later. When IBC came, there was no reference to limitation, right? Now, because of that, a lot of disputes started arising in this. In one of the earliest judgment in this dispute, NCLT had discussed the question of time bar debt and held that the provisions of Limitation Act will be applicable to proceedings under IBC, and the claim which was time barred could not be considered by NCLT as the same as enforceable. So NCLT said the time barred claim cannot be considered, right, in IBC proceedings also. This later was followed by other judgments of various benches of NCLT. Thereafter, NCLAT also got into the issue, and it held that Limitation Act is applicable to IBC, but it left certain aspects unanswered. In June 2018, Section 238A was inserted to provide that Limitation Act is applicable because there was a gray area, because there was a lack of clarity. The code was amended to bring in Section 238A. Now, whether IBC is a complete code or not, this has been decided in many judgments. But when you see Section 238, which was brought in 2018, before that you had innovative judgment, right? So the Honorable Supreme Court in the case of Innovative Industries after analyzing the entire code, it says that there can be no doubt, therefore, that the code is a parliamentary law, that it is an exhaustive code on the subject matter of insolvency in relation to corporate entities, and is made under entry 9 list 3 of the 7th schedule of constitution as under. So basically, in the judgment of inventive, it was held that IBC is an exhaustive code in itself. It's a complete code in itself. So it is settled that IBC is a complete code, and remedies provided by it covers all the matters. IBC cannot be guided by other legislative enactments. Now, when you come to essence of law of limitation, so why was Limitation Act brought in? What is the object of limitation? So Limitation Act is your 1963. In fact, the third law commission had commented and suggested the introduction of Limitation Act, which was in 1962. The act came in 1963. The Limitation Act was enacted with the object of consolidating and amending the law of limitation of suits and other proceedings. In the third report, Law Commission explained the reason behind the implementation. Why Limitation Act was required was explained by the Law Commission. It says that the utility of a statute of limitation has never been a matter of serious doubt or dispute. It has been said that the statute of limitation is a statute of repose, peace, and justice. So the utility of Limitation Act has never been disputed. Nobody has raised concerns on that this is wrong, it should not be there. It is one of repose because it extinguishes stale demands in Quiet's title, right? So Limitation Act extinguishes stale demands, which are like very old demands, and Quiet's the title. It confirms and affirms the title. The words of John Boyd, controversies are restricted to a fixed period of time, lest they should become immortal while men are mortal. The people in the controversy might not remain. The controversies will keep on remaining. So to put an end to that, there should be a limitation period. It secures peace as it ensures the security of rights, and it secures justice as by lapse of time, evidence in support may have been destroyed. There can be thus be no doubt that it rests on sound policy. So Limitation Act is based on sound policy. The operation of law has been explained by Lord Plunkett in a very good metaphor. He stated that time holds in one hand a scythe and in the other a hourglass. Scythe is what you use for like cutting grasses. So he said the time in one hand holds a scythe and in the other an hourglass. The scythe mows down the evidence of our rights. With passing time, the evidence gets depleted, while the hourglass measures the period which renders that evidence superfluous. So with passing time, suppose 3 years is the limitation period. With passing time, the evidence gets depleted, and the time runs out. So it quiets the title. Commenting on this, a learned author also observed that the metaphor could have been contemplated by adding. So for Indian context, somebody added that the hourglass certainly decay, the glass can be broken, and the sand escape. So basically to quiet the title, to put an end to litigation, that it should not just keep on cropping up. Even if the person is not there, the issue still persists and it keeps on cropping up. So for that, Limitation Act was brought in. Now, provisions of Limitation Act. So section 18 states that if there is a written acknowledgement of the liability before expiration of limitation period, then the new limitation period will be started from the date of acknowledgement. So if I owe a debt to you and 2 years passed, then I write a acknowledgement saying that I acknowledge that I'm indebted to you. From that acknowledgement, again the 3-year period will start. Section 29, subsection 2 of the Limitation Act states that for any suit, appeal, or application under any law prescribes a different limitation period. Basically, what it says is if any other law defines any other limitation period other than what is given in Limitation Act, it shall be deemed that such period in that other law is included in the Limitation Act, right? Let me just get my charger. Give me one moment. Yeah. Now, we saw that Limitation Act. Why is it important? It helps to affirm the legal issues. Honorable NCLAT wanted to plug the gap which was there in the law, right? So in an attempt to plug the gap, they passed a common order. So there was the case of Speculum Plast Private Limited versus PTC Techno, Parag Gupta versus BK Educational Services. This BK Educational Services went up to Supreme Court, and Ashley Infra versus LDS Engineers. NCLAT held that in the absence of an explicit provision excluding the applicability of Limitation Act in proceedings under IBC, it is open for courts to scrutinize the provisions of IBC to conclude whether limitation is excluded before Section 238A was brought in. NCLAT said that since there is nothing given in IBC to exclude Limitation Act, we give the discretion to courts, like NCLT is given full discretion to decide whether limitation will apply or not. NCLAT also held that several sections of IBC provides timelines for several stages. So basically they said that Limitation Act will have some timeline, but CRP in the code itself has timelines for several activities. Okay. Further, it was held that Limitation Act cannot be made applicable in an application for insolvency by a corporate debtor. So Section 10 is filed, and NCLAT said it's a voluntary application. Okay. So Limitation Act cannot be applicable. Another interesting observation made by NCLAT was Article 137 of Part 2 of Limitation Act prescribes a limitation period of 3 years from the date that the right to apply accrues. Then NCLAT gave NCLT under the code absolute authority to decide whether or not a claim is belated or barred. So complete discretion is given to NCLT by NCLAT to decide whether a claim is belated or barred. NCLAT ruling would have definitely increased a lot of litigations and would have resulted in appeals. So Section 238A was inserted to put an end and give a proper clarity that Limitation Act will be applicable to IBC proceedings. Now, although the provision came in, the aspect of whether the application of Limitation Act would be prospective or retrospective, that is, whether the applicability of Limitation Act would be from 1st December, which is when the IBC was started functioning, 1st December 2016, or not. So whether it be retrospective or prospective, these things were still not clear. Honorable Supreme Court, in its judgment in BK Educational Services versus Parag Gupta and Associate, addressed the intricacies involving applicability of Limitation Act. So the following is from BK Educational Services. So the BK Educational Services case, Supreme Court referred to Insolvency Law Committee report of March 2018. Whenever there is an interpretational problem, whenever they want to identify why a specific provision was brought in. So for like constitution articles, we refer to Constituent Assembly debates. Similarly, here in IBC, when there's a interpretational issue, courts do refer to BLRC report. Similarly, when 238 they wanted to interpret, they have to rely on Insolvency Law Committee report. So the Supreme Court referred to the Insolvency Law Committee report March 2018, which stated that the intent of the code was not to array the code as a fresh opportunity for creditors and claimants who did not exercise their remedy under existing laws within the prescribed period. The committee thought it fit to insert a specific section applying Limitation Act to the code. So, if somebody had a debt to be recovered, but he slept over his rights for more than the limitation period, the code does not give him a new opportunity to resurrect that claim, right? So the committee thought it fit to insert a specific section applying Limitation Act to the code so that time barred claims are not brought into IBC. It is evident from the language of the report that the court did not intend to resuscitate the stale and dead claims. Then the court read IBC with the Companies Act. According to the combined reading of Companies Act with IBC, it is evident that NCLT was meant to discharge such powers and perform such functions and duties that are conferred on it, not merely by Companies Act, but also under any other law for the timing in force. So NCLT is required to also perform duties under other laws. Thus, it is evident that the application of Limitation Act would continue upon the said proceedings, as it would be absurd to assume that just by virtue of being transferred to NCLT, the doctrine of limitation would cease to apply. So basically what they're saying, if maybe some cases lying in some other court, probably DRT, right? And now we all know that proceedings had to be transferred to NCLT. So to say that the doctrine of limitation will end just because there's a transfer to NCLT would not be making logical sense. So they said it is evident that the application of Limitation Act would continue. Limitation Act applies, it continues. Even if there's a transfer, you cannot get a fresh lease of life just because it's transferred to NCLT. It would be prejudicial to interpret that the said provision is to mean that the fresh filings before NCLT would be exempt from the bar imposed under Limitation Act, but the transfer proceedings cannot avail the same. Right? So it will juxtapose two different things, two contrary meanings will come up if we allow that. So Limitation Act applies. Just because I'm filing before NCLT or there's a transfer to NCLT does not revive the limitation. Supreme Court relied upon the judgment of Andhra Pradesh Power Coordination versus Lanko Kontapalli to conclude that the legislature did not contemplate enabling a creditor who has allowed the period of limitation to set in and allow such delayed claims through the mechanism of the code. The code cannot be triggered in the year 2017 for a debt which was time barred much earlier. So if the debt was time barred in 2013, 14, 15, right? It expired the limitation period. Then you cannot bring that to IBC. You cannot file an application based on that claim before NCLT, as that would lead to absurd and extreme consequences of the code being triggered by a stay or debt claim, leading to drastic consequence of instantly removing of the present board of directors permanently, which may ultimately lead to liquidation. The court says if we allow such petitions of time bar debts to come to IBC to trigger CARP, it will result in drastic consequences, including removal of the board of directors because RP takes over, and also it might drive the company into liquidation. This being the case, expression debt due defined in the code would obviously refer to the debts that are due and payable in law, the debts that are not time barred. So in when we see CARP triggering, it depends on debt and default, and debt which is due and payable. A time barred debt cannot fall under this definition. In view of, they also illustrated the innovative industries judgment. BK Educational Service judgment also referred to innovative judgment of Honorable Apex Court. Then it was concluded that it is clear that the provisions of Limitation Act will be applicable to IBC, including the applications under Section 7, Section 9. So any triggering application also it will apply. It will have retrospective effect from 1st December 2016. The 238A was brought in 2018. Court said that it will have retrospective effect from the date the code was made effective. Thus, it is safe to conclude that if the creditor attempts to file an application in lieu of a debt, wherein the default had occurred 3 years prior to date of filing, the said application would attract the provisions of Article 137 and thus be barred. So, in Limitation Act, you have schedule and you have articles which mention the timelines for different provisions. Okay, so the court is saying that if the creditor attempts to file application for a debt for which the default had occurred 3 years prior, Article 137 says that 3 years is the limitation period. So if you trigger CARP for a default which occurred 3 years prior, then it will be time barred. The only exception would be there where Section 5 of the Limitation Act may be applied to condone the delay due to appropriate reasons. Now we come to the other judgment of Honorable Apex Court. Babulal Vardarji Gurjar versus Veer Gurjar Aluminum Industries. Now here, so first clarity came from BK Educational Services, where Supreme Court said that 238A is fine. It will apply retrospective. Limitation Act is applicable. Okay, so they laid the groundwork there for Limitation Act. Then you had the Babulal Vardarji Gurjar case of Honorable Apex Court. Now in this, on December 2007, you will have to see the facts a bit more clearly to understand the timelines. December 2007, banks, including certain banks, sanctioned and extended various loans, advances, facilities to the company. The company executed various security documents in 2008, 2009, including of equitable mortgage. And lastly, on 2010 also, various additional security documents were executed. Company defaulted the payment of amount due. Just hold on a minute. Sorry, that was a lawyer's part. Yeah. So lending was done by certain banks. Security documents were issued as late as 2010. Then the company's account was classified as NPA on 2011, July 2011, right? And one of the banks also classified it as NPA in August 2011. Now remember the date, July 2011. The issue involved was whether the application made by respondent under Section 7 of the code is within limitation. Supreme Court held that the application made by respondent under Section 7 of the code in the month of March 2018, application is made in March 2018. Default was 2011. Seeking initiation of CRP in respect of the company with specific assertion of date of default as 8 July 2011 is clearly barred by limitation for having been filed much later than the period of 3 years from the date of default as stated in the application. In the interest of justice, we also make it clear that the observations in this judgment are relevant only in regard to the issue determined that the application under Section 7 is barred by limitation and not beyond. They are saying it is the observation made is fact specific, case specific, based on the circumstances of the case. In other words, nothing in this judgment shall have bearing on any other proceeding that shall be dealt with on its own merits and accordance with the law. Right? This is a Supreme Court judgment. Very clearly, Supreme Court says this judgment is based on the facts of this case alone. Don't apply it anywhere else. But what happened after this judgment? We had contradictory judgments from NCLAT and NCLT. So while in the Babulal case, the Supreme Court examined the applicability of principles of Section 18 to be case-specific facts, the observations made in the judgment. Now we are going to go through Lakshmi Surana, the next big case of Supreme Court in the arbitration area, in the limitation area. Okay. How Lakshmi Surana came into picture. So Babulal case, clearly Supreme Court said it's only based on facts of the case. Okay. The observations made in judgment were relied upon by subsequent decisions of NCLAT and NCLT to hold that Section 18 would not apply to applications for initiation of IBC proceedings. So when Supreme Court says the debt is time barred, that's why we are not applying. There was a misunderstanding created, and the observations of the Supreme Court are used by NCLT and NCLAT to say that Section 18 itself is not applicable. So that resulted in conflicting judgments. Several conflicting judgments came to be posted after that Babulal judgment. For instance, NCLAT in the case of Jagdish Prasad versus Allahabad Bank relied on the Babulal to hold that the date of default cannot shift on account of acknowledgement because extension was sought under Section 19. So based on Babulal judgment, NCLAT said that we cannot shift the date of default based on acknowledgement. So by limitation, if you look at the Supreme Court judgment, if there is acknowledgement, the limitation revives. Okay. But depending on a wrong interpretation of Supreme Court verse, they said Section 18 will not apply and there cannot be extension of date of default. And that's why you cannot proceed with IBC. In a subsequent decision, NCLAT in Yogesh Kumar Jaswantal Thakkar versus IOB distinguished Babulal on facts and applied Section 18 to extend the period of limitation. So in one case, they denied, one case they applied. Later, a 5-judge bench of the NCLAT in the case of Bishal Jaiswal relied on Babulal to hold that Section 18 is not applicable to proceedings under IBC. So here in Bishal Jaiswal, 5-judge bench upheld that Section 18 will not be applicable to proceeding under IBC. Now, when the case went before Supreme Court, the Supreme Court reiterated and held that the intent of IBC was not to reopen revived time-barred debts. It clarified that accrual of fresh period of limitation in terms of Section 18 is under the Limitation Act itself, and it will not be a case of giving a new lease to time-barred debts. Supreme Court said, this is not what we meant, what you are doing. We meant that you cannot allow stale and dead claims to come back. But we never said that Limitation Act does not apply. If there is an acknowledgement, the period of limitation revives. So it clarified that the accrual of fresh period of limitation is in the Limitation Act itself. And it's not a case of giving a new lease of life to time-barred debts. Accordingly, the court held that there is no reason to exclude the effect of Section 18 to the proceedings initiated under IBC. The court also clarified that its decision in Babulal did not rule out on the application of Section 18 and observed that this court had not ruled out the application of Section 18 to the proceeding under the court if the fact of the situation so warrants. If the fact requires, you have to apply Section 18 of Limitation Act. The Supreme Court held that when the principal borrower and or the corporate guarantor admits and acknowledges the liability, a fresh period of limitation is required to be computed from the time when the acknowledgement was so signed by the principal borrower or corporate guarantor, provided the acknowledgement is before expiration of the period of limitation. So, if somebody acknowledges their debt, a fresh limitation period starts. Then, in relation to liability of the guarantor, the Supreme Court said that such liability is coextensive with the principal borrower when the so if the principal borrower acknowledges it, applies equally to the guarantor also, because as per 128 of Contract Act, the guarantor's liability is coextensive with that of principal borrower. The Supreme Court interpreted Section 238A as intended by making all provisions of Limitation Act as applicable available to proceedings under IBC. The Supreme Court found no reason to exclude the applicability of Section 18. Article 137 of Limitation Act, which provides that the period of limitation is for 3 years from when the right to apply accrues, is applicable. So, Article 137, Section 18 is applicable for computation of limitation period for initiating proceedings under the code. From the findings and reasoning given by the Supreme Court with Lakshmi Patsurana, it would also follow that other provisions of Limitation Act also will apply to IBC. Now, all this interplay related to some more questions. One question is whether an entry in the balance sheet of the company could be treated as an acknowledgement in writing for the purpose of Section 18 of the Limitation Act. So if there's an entry in the balance sheet that such debt is due to such party, will there be an acknowledgement? Supreme Court answered this question in the affirmative in this judgment and held that by operation of Section 18, unless adequately caveated in the books of company, an entry in the balance sheet can amount to an acknowledgement of debt in writing, which would start a fresh limitation period. So, if the debt is acknowledged in the balance sheet, it will result in revival of the fresh limitation period. Section 18 of Limitation Act. What does Section 18 say? Effect of acknowledgement in writing. Where before the expiration of prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property has been made in writing, signed by the party against whom such property or right is claimed. So if you are claiming something from me and I have given in writing that I acknowledge, right, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. So, if there is acknowledgement in writing, fresh limitation period start. Following pointers summarize in a nutshell the law relating to Section 18. So, these critical aspects should be there for the limitation calculation. Section 18 of the Limitation Act says that an acknowledgement in writing by a party of a subsisting liability or right has the effect of starting a fresh limitation period from the date on which the acknowledgement was signed for filing an action. Such an acknowledgement does not create a fresh cause of action, but merely renews or extends the existing cause of action. So there is a revival. There's no new creation. It's only a revival of action. In order to claim the benefit of section, a party has to show that the following requirements have been fulfilled. So for Section 18, you have to make sure the following is there. First, there should be an acknowledgement of liability in respect of property or right. Second, the acknowledgement must be in writing by the party against whom such right is being claimed. Third, the acknowledgement must be made before the expiration of the period prescribed for suit or application. So before 3 years lapse, you have to again get an acknowledgement. For Section 18 to apply, the acknowledgement need not be accompanied with a promise to pay and can be express or implied. The only requirement is that the acknowledgement must indicate the existence of a jural relationship. So it should basically say that I acknowledge I have this debt due, right? It need not accompany a promise to pay. Now, pre-existing law on the application of Section 18 for balance sheet entry and all. Supreme Court as well as various high courts held that entry in balance sheet of a company was capable of extending the limitation period, notwithstanding that the balance sheet was not addressed to the creditor or was prepared under compulsion of law. Okay, but these were not cases under the IBC. So there are a lot of judgments of apex court and high courts which says that entry in balance sheet is as good as an acknowledgement. Although it is made under a statutory compulsion under Companies Act, it's not addressed to the creditor, but still it's a valid acknowledgement. Now, we had an interesting case of V. Padmakumar versus Stressed Asset Stabilization Fund. This was in Honorable NCLAT. So here, by a majority of 4:1, it was held that an entry in the balance sheet would not have the effect of renewing the limitation period. NCLAT stated that since the balance sheet was prepared under statutory compulsion, it cannot be treated as a valid acknowledgement. So NCLAT says entry in balance sheet is not a valid acknowledgement. Subsequently, a 3-judge bench in Bishal Jaiswal case arrived at the conclusion that the judgment of the majority was directly contrary to the law laid down by Honorable Supreme Court and High Court and required reconsideration. So Vishal Jaiswal judgment included only a 3-judge bench was there. The Padma Kumar case had a 5-judge bench. So this 3-judge bench says that this requires reconsideration, but they cannot override a 5-judge bench judgment, right? Since the judgment in V. Padma Kumar was given by a larger bench of 5 benches, the same could not be overruled and the matter was referred to a larger bench. Upon entering reference, the larger bench said that the 3-judge bench had no power to refer the matter to a larger bench and in essence reiterated that the reasoning it adopted in Padma Kumar case. So, larger judge bench first said that the Bishal Jaiswal bench did not have any power to refer to the larger bench. Second, they upheld the Padma Kumar case principle, saying that Section 18 will not. So, saying that the entry in balance sheet will not result in valid acknowledgement. Now, what are the problems in this approach of Honorable NCLAT in Padma Kumar case? The reasoning and conclusion of NCLAT is difficult to accept and problematic for multiple reasons. First, the judgment passed by NCLAT ignores the law laid down by Supreme Court on this point and incorrectly proceeds to hold that entry in balance sheet does not serve as an acknowledgement for Section 18 of Limitation Act. Second, requirement that the document constituting an acknowledgement must not be prepared pursuant to a mandatory statutory duty is not found in section. Basically, Section 18 does not say that this should not be the way. Okay, that a mandatory prepared financial statement, an entry in the mandatory prepared financial statement under Companies Act cannot be treated as valid acknowledgement. This is not written in Section 18. So, NCLAT is by saying that this is a statutory made financial statement and it cannot be basis of Section 18. By saying such thing, NCLAT is adding a onerous provision, which is not there in law. The law says there should be acknowledgement. NCLAT is saying that an entry in the balance sheet will not be an acknowledgement. So when something is not provided like that in the law, now you are adding some onerous conditions to the act, which is not correct. Thirdly, the NCLAT placed reliance on the judgment of Supreme Court in Babulal case to hold Section 18 does not apply. Although the Supreme Court in Babulal case very clearly said this is based on the facts of this case, and there the default was in 2011. The case was getting filed in 2018, so the debt was time barred. Fourthly, the purpose of Section 238A was to ensure that the time barred debts are not given a second lease of life. In other words, the purpose of the section was to exclude claims which were lost as a result of acquiescence, laches, or inaction by a party. A party which did not bring an action but whose debt has been acknowledged by the company in its balance sheet can hardly be treated or viewed as par with the party which has accused or given up its right. So you cannot equalize the two parties. One who has slept over his rights, not taken any action. Second, a party whose debt is getting acknowledged by the company time and again. So you cannot equalize these two parties. As a result of the NCLAT judgment, financial and operational creditor could not initiate proceedings under the IBC despite their debt being acknowledged by the corporate debtor in the balance sheet. Litigants faced with unique situation where an entry in balance sheet would act as an acknowledgement for the purpose of recovery under other legislations or through civil suit, but not for application under Section 7(9). Therefore, for the same debt or liability, there were situations where even though limitation was extended for a suit or recovery under DRT, it was not extended for the initiation of proceeding under IBC. So, same thing I'm able to use in some other framework, but I'm not able to use in IBC. That was the problem created from the Padma Kumar judgment of Honorable NCLAT. Then all of this went to Honorable Apex Court out of appeal in Bishal Jaiswal judgment. Supreme Court disposed of the appeal with and other similar appeals also. So the reasoning given by Supreme Court is, first of all, they overruled the Padma Kumar case and Bishal Jaiswal case, right? Supreme Court identified two questions. One, whether Section 18 was applicable to proceedings under IBC. Second, whether an entry in the balance sheet would result to an acknowledgement in writing. Supreme Court held that it was a settled law that Section 18 of the Limitation Act was applicable to proceedings under the IBC The court noted the use of phrase as far as may be in section 238A and held that there was nothing in 238 of IBC to suggest that section 18 cannot be applied. Section 18 is applicable. To fortify the conclusion, the bench referred to previous judgment pronounced by Supreme Court where section 18 had been applied to proceedings under IBC. On the balance sheet entry provision, after confirming that section 18 would be applicable, Supreme Court characterized the duty and purpose of preparing and filing of balance sheet. While the court accepted that the preparation of financial statement was under Companies Act under section 92, 128, 129, etc., it held that the same did not preclude the balance sheet from acting as an acknowledgement. The Supreme Court upheld the ratio of its previous judgments as well as the judgments of the High Court, wherein it was accepted that entry in the balance sheet could be an acknowledgement in writing under section 18 of Limitation Act. The Supreme Court, while affirming the dicta of Calcutta High Court, Honorable Calcutta High Court and Honorable Delhi High Court, held that simply because the balance sheet is prepared under compulsion of Companies Act, opposing party cannot be precluded from relying upon the entries found as an acknowledgement for the purpose of Limitation Act. So simply because it's under Companies Act, that's under a mandate, it's not addressed to creditors, does not mean the other party cannot rely on it to prove an acknowledgement. The court explained that even though there is a compulsion to prepare balance sheet under law, there is no compulsion to make or include any particular entry in the balance sheet. The law says you prepare balance sheet. The law did not say you acknowledge your debt, right? So you are acknowledging. So that is an valid acknowledgement. Accordingly, Honorable Supreme Court set aside the judgment of V. Padma Kumar and Vishal Jaiswal of Honorable Enclad for failing to take note of the law laid down by Honorable Supreme Court and High Court. Caveat identified by the Supreme Court. Supreme Court, however, refrained from laying down an absolute rule and has added a caveat to the application of Section 18 to entries in the balance sheet. It was held that every entry relating to a debt would not qualify as an acknowledgement for the purpose of Section 18, and that an entry must be understood in the context which it occurs and the light of the notes annexed to the balance sheet. So they have put a caveat very nicely, neatly. They have said that every entry will not be an acknowledgement of debt. The entry has to be understood in the context and in reference to the notes attached to the balance sheet. So what is the current legal position? The law on the question of limitation can be framed shortly as in limitation period for filing application under section 7 or 9 would be 3 years from the date of default, since the two sections do not contemplate a suit but rather an application. So it's an application, so 3 years from date of default. By virtue of Article 137, limitation would be from date of default. However, the 3-year period would restart if the debt has been acknowledged in the balance sheet of the company. The answer to the question whether the particular entry in the balance sheet qualifies as an acknowledgement or not depends on the facts and circumstances of the case and must be read with the notes annexed to the balance sheet. So, entry in balance sheet is an acknowledgement, but it depends on the facts and circumstances. Each case might be different, and you will have to refer to the notes in the balance sheet. Now, what are the key takeaways for creditors and companies? Creditors must be vigilant and ensure that the company includes an entry acknowledging its liability towards the company. Further, a number of debts which may have been written off in the books of the creditors on account of being time barred may still be recoverable if the debt has been acknowledged in the books of corporate debtors. So, bank might have provided for a return off, but the company is still showing in books. So, the recovery can still be possible. So, make sure that acknowledgement is there in the books. Companies and corporators must be careful of the entries being made in their books of account and balance sheet in lieu of the amounts of debt taken by them. In case of a disputed sum, which the corporator has no intention of admitting, the entries in the books of account and balance sheet must be accompanied with proper caveat. So, you should put proper disclaimer and caveat. Otherwise, this will lead into an acknowledgement. So, from this, I believe that, the Limitation Act, at least that part is clear. Now, there are very many cases of arbitration being undertaken during CRP, right? So there might be some contract, and so we had a gas-based gas-based power plant which used to derive gas from ONGC and GAIL. And during CRP and liquidation, we had an ongoing arbitration with them. Okay. Now it can result into very unique situations because any claim by the other party should be filed before the liquidator. But if an arbitration is going on, and I file a claim as a liquidator against them, they will obviously file a counter claim in the arbitration itself, right? And that's not before the liquidator, that is before the arbitration. And section 14 says enforcement of awards is not possible during moratorium. But there are also judgments which says if anything is favorable for the company or the corporate debtor, those cases can be taken up. Now, as we also saw, execution of arbitration proceedings is not possible during CRP. So if somebody won an arbitration against me prior to CRP, he might file a claim with me as a before the RP, right? But he cannot get that arbitration award executed while the CRP is in picture, because that might result in assets being sold or assets being realized, which is a violation of moratorium. There was a case of Apex Court, Vidarbha Industries Power versus Axis Bank, where the court said that there is an arbitration award, the amount of which is much larger than the debt due. So NCLT should reconsider these things before admitting any Section 7 petition. So that was on the arbitration. Let's take a 5-minute break, and we'll come back on PMLA, and we'll then look at some other provisions also. Just a 5-minute break. Can we restart? If just anybody can put it in the chat box, I can continue with the session.
Sir, may I ask a question, please?
Yes, yes, please, sir.
So there is a companies under CIRP. The whether it is compulsorily required or it is recommended whether to hold the board meeting for the approval of financial statements for the period of CIRP, since the powers of the board are suspended one. So whether it is whether it is it is to be treated as a normal company, like we approve the financial statements from the board of directors and request the board to recommend to approve the same by the AGM, or whether the AGM to be held or the simply to approve the financials from COC would suffice.
If I may answer now, sir. Yes, so you have to hold a board meeting. You have to have an AGM because you are required to comply with applicable legal framework, which includes the Companies Act. So if the quorum is not there, that's a separate issue. If the two directors are not there as required by Companies Act, you cannot have a board meeting. Then the RP signs the financials, or directors refuse to sign the financials, RP signs the financials. But technically speaking, legally speaking, you are required to hold a board meeting. You are required to get the financials approved, adopted even by members in the AGM. In our CRP companies, during CRPs, we have AGMs. We call the members. They vote also by show of hands. So it is required. It is the company has to comply with Companies Act.
Okay, it is to be treated
Yes,
during IRP itself. It is to be treated as a normal company and
yes,
the
yes,
normal.
yes, yes, sir. Yes,
And
sir.
if the board of directors are absconding 19-2 and contempt application is pending before the adjudicating authority, then what we should do? Whether the to
So
approve from the COC?
approval from the COC is not required for Section 19. In fact, COC will not approve your financial statements.
So
That
how
is
to
not, yeah. So that is not the duty of COC to approve the financial statements. Till before CRP starts, okay, the suspended management is duty bound to prepare the financials. Okay. COC will not at all come into the picture. Once CRP starts, RP's duty start. RP will have to, if he has, suppose 31st March 2022 is the cutoff date. CRP started in June 2022. RP might say that I was not even in the picture when the financial year ended. So how am I supposed to take responsibility for the financial? But even then, he is required to comply. If the board had prepared the financials, but board refuses to sign, RP might sign and put a disclaimer saying that I have signed based on what the board has given me. I have not verified this independently, and I was not even there when the financial year ended. So you can put proper disclaimers, because board might refuse to even cooperate. If the board cooperates, we take the director's signature as well, RP signature and two director signature as well. We take. We hold a
so
board.
directors will also sign the financial statements?
Yes, yes. As per Companies Act, the directors, CSF are required to sign. If
And
they don't cooperate,
in case the directors are absconding and they are not cooperating,
RP will sign.
RP will sign. And
Yes.
and what shall be the date of approval? What shall be the date of balance sheet?
Financial year end. That doesn't change. You have to prepare balance sheet on March end, right? March 2022, March 2023. That will be your balance sheet date. That doesn't change.
So in that case, there will be no board meeting, no AGM. Simply the RP will sign the financials.
You cannot hold a board meeting because of practical challenges, as the directors are not there. Quorum you cannot meet. Without quorum, you cannot do a meeting. That fact you can record in the financial itself. So as an RP, if directors are there, everything is there, you will try to comply. If nobody is cooperating, quorum is not there, then it is not your fault that there is a non-compliance. So we have to document that we have done our effort. That's all.
I have a query.
And if the
Yes,
directors directors are there, they are ready to comply, then
The whole
they
board
have
meeting, yes.
balance
Yes, yes,
sheet.
they have to sign. Yes, yes. That's a
and
Companies Act requirement. 2 directors, CS, CFO.
and AGM to be convened
Yes, yes.
the normal.
Yes, yes, of course, of course.
The I have another question. What is this? What is the situation if the asset of the company is attached under the PMLA by the ED? What is the present situation now? Whether the asset which has been seized or which has been attached by the ED, whether it shall form part of the asset of the corporate
So we
debtor.
have PMLA slides, which I'll be projecting now. You'll get
Hmm.
more clarity as and when we do that, sir.
Fine, please. Thank you so
Sir
much.
Rajiv, if you want to ask. Yes, sir.
Uh, Regarding the limitation, as you said, it will be applicable in case of application under section 7 or
Yes,
uh,
9.
9. So they will be applicable in case of claims which are being filed, and RP has to look after that also.
When we say section 7(9), we are talking about triggers of CRP. Of course, when claims are coming to RP, the claims are also time barred and it's not acknowledgement as a debt. Then RP can say that, it's a time barred debt and this cannot be filed before me. That's a legal point, yes.
Okay.
So, see RP as a director only, sir. Okay. So, if you are director of a company, you are the management of a company, some debt is time barred. He cannot proceed against you legally to recover it. Correct? So RP will also be like that. He'll be like, it's a time bar debt. You're filing a claim for that. I cannot consider this because it's not a debt due and payable then. It's a time bar debt. It's not debt due and payable. How do I accept this? Then the other party might go to NCLT. He takes an order from NCLT, we'll follow NCLT's action.
Okay.
The trigger is debt and default, and debt is due and payable, and due and payable is what is not time bar. Time bar is not even due and payable. It cannot be even a claim. Right? Anybody else? Any other queries? We will start with PMLA. Okay. So very briefly, everybody will know a bit of about PMLA at least. So when criminally tainted money is got in and using that you acquire property, acquire assets, it leads to an offense of money laundering. Now, how this term money laundering came into picture was Al Capone, who was a famous mobster in the USA. He used to establish laundry business to turn his black money into white money. So from that, the term money laundering came. Money laundering is used for disguising or concealing illicit income in order to make it appear legitimate. So you layer the transactions, illicit transactions, to make it appear legitimate. It is being employed by launderers worldwide to conceal criminal activity associated with it, such as drugs, arms trafficking, terrorism, etc. As per UNODC, it's a survey. Money laundered globally in 1 year is 2 to 5% of global GDP, or $800 billion to $2 trillion in current US dollars. Average global money laundering risk has increased from 5.22 to 5.3 out of 10. 50% of money laundering goes undetected across the industry. 62% of compliance officers say criminal activity is getting harder to spot because they are finding innovative ways and means to launder money. Money laundering means the act of procuring, concealing, and turning illegally obtained funds into legitimate proceeds. So procuring, concealing, and turning black money to white money. It comes under same branch as more serious smuggling crimes like drugs, human trafficking, robbery, etc. This money is generated by investing in the black market and under the table crimes such as drug trafficking, illegal arms sale, even operating prostitution rings, bribery, computer fraud schemes produce large amount of capital for them. There are 4 basic stages in money laundering. First is procuring the money through illicit activities. By drug trafficking, etc., they procure the money. Second step is known as placement. In this step, money obtained is then turned from black to white and injected into legitimate finances. So you do black to white and you invest it into proper financial channel. Third step is known as layering. in which small accounting tricks are used to spread this money over numerous transactions to remove trail back to its actual source. So when you do an audit trail, you go back and see where this exactly is coming from, right? So layering is done, multiple layerings of the transaction is done to make that trail difficult. The fourth step is integration, in which the now clean money is taken out of and used for normal transaction or to further invest in illegal activities. Now that money is turned white, now I can do it for more investing, or I can even use it for other illegal activities. So this is the money laundering cycle: collection of dirty money by illegal activities, then placement, right? The money is integrated into the financial system, then you start layering it. Multiple layers you created, and then you integrate it by again putting into the channel back again by purchasing something, or again investing in illegal activities. So black to white and then white to black. So it's a vicious circle. Placement stage of money laundering. So this is the first stage, which involves physical disposal of cash. The launderer introduces his illegal profits into the financial statement. The placement is accomplished by depositing the cash in domestic banks or in other types of formal, informal financial institutions. This is done by breaking up large amounts of cash into small amounts. If you put a large amount, concerns will be raised. So they break it into small amounts and then deposit into bank. This cash is usually siphoned off across the borders for deposit in foreign financial institution or used to buy high value goods such as artwork, etc. Second stage is layering. The launderer engages in a series of conversions and movements of the funds to distance it from their source. So multiple layers will be created. Funds might be channeled through the purchase and sale of investments like bonds, stocks, traveler checks. Launderer might simply wire the funds through a series of accounts at various banks across the globe, particularly those jurisdictions who do not cooperate with our country. In some instances, launderer might disguise the transfer as payment for goods or services, giving them a legitimate appearance, like koi consultant ko we paid, some goods we bought, some office equipment was bought, like that they layer the transaction. A number of rotations to slush the funds are given through banks, and this complex layer of financial transaction is carried out to diverge the illicit proceed from the original source. We create so many layers that you'll never identify that this money had come from an illegal source. Then high value goods and monetary instruments, whatever you bought, are resold, and then proceeds are invested in real estate and legitimate businesses. So whatever high value item I bought, I resold them, again got the money, and I invested them in legitimate businesses. Shell companies are also used, dummy companies are used for these transactions, and they are used in layering. Then you have integration. This is the stage where funds are returned to the legitimate economy for later extraction, right? So I invest in a company, I purchase real estate. Somewhere I'm coming back to the legal system. Several forms of money laundering. One is called smurfing. It is when someone breaks up a transaction involving a large amount. A large amount is broken into smaller transactions below the reporting threshold. For example, in India, to deposit more than 50,000 in bank, you need a PAN card. But below that, 49,999, I don't need a PAN card. So depositing in small amounts, that's called smurfing. Bulk cash smuggling. When a huge amount of money is physically smuggled in cash to faraway places like offshore banks that do not have money laundering checks in place. So some country which does not have PMLA jurisdiction, I'll go there, I'll deposit. Cash intensive business. These businesses conduct dealings mainly in cash and thus can sneak in illicit money along with legitimate money earned into their account. So many eateries we see, restaurants we see, everything operates on cash basis, right? So cash intensive business have a good scope of accepting illegal money, mixing them with their legal money, showing expenses, etc. Trade-based laundering. This is one of the most complex way of laundering. It involves under and overvaluing invoices for concealing movement of money. So I purchase goods, I sell goods. I can anytime inflate or deflate the invoice value. Then you have some more modes of money laundering. Shell companies are used. Round tripping. Money is transferred to offshore accounts with minimal records and transferred back as an investment. So I take it to some other country with minimum records, minimum compliances, and then I bring it back into India. So then gambling, small bets with large returns. So you see all these betting apps these days. These are also, there are concerns on money laundering on these apps. In fact, Paytm investigation, if you are seeing, RBI has raised a lot of concerns that, you don't have any KYC in place. It might lead into money laundering activities. black salaries, you don't have employees, you're paying them just on name basis. Phantom employees are there, that can be money laundering activity. Tax amenities, legalizing unreported cash and assets in tax haven. So I take unreported cash and I legalize it in tax havens in outside countries. Transaction laundering, when a merchant unknowingly processes illicit money for other business. So use somebody's POS machine and transfer it to somebody. He does not even know that his machine is being used to get money on illegal activities. Value tampering. Money launderers may look for a property owner who agrees to sell property at a price below actual value and then accept the difference in under the table, means cash. So property is worth 100 rupees. The seller is saying, give me 80 in bank and 20 in cash. So these real estate transactions have a lot of cash component. So PMLA Act was brought in to curtail money laundering activities. An act to prevent money laundering and provide for confiscation of property derived from or involved in money laundering and for matters connected thereto, right? So that was the background for PMLA. A lot of countries had, there was a political declaration which was done into 1990 by United Nations, and member states were asked to adopt money laundering checks. So a lot of countries under global guidance also got in the PMLA framework. So in India, it came in 2002. The law's three main objectives are to prevent and control money laundering, to confiscate and seize the property obtained from laundered money, to deal with any other matters that are connected with or arise out of money laundering. Under PMLA, the Enforcement Directorate is the body that has the right to conduct a money laundering investigation. So we all know about ED, and you also have an interplay with the Foreign Exchange Management Act 1999 or Prevention of Money Laundering Act. So ED takes care of these two laws, FEMA and PMLA. What are the offenses under PMLA? Offences mentioned under Part A and C of Schedule of the Act will attract this provision. Part A includes offences under the Act, namely Indian Penal Code, Prevention of Corruption Act, Narcotics, Drugs, Antiquities and Art Treasure, Trademark Act, Wildlife Protection Act, Copyright Act, and Information Technology Act. So these are under Part A offences. Part B includes offences that are mentioned in Part A but are a value of 1 crore or more. So Part A offences of value 1 crore or more comes in Part B. Part C includes trans-border crimes. Various actions that can be initiated against persons are freezing or seizing of property and records, attachment of property. Money laundering is punishable with rigorous imprisonment for a minimum of 3 years and maximum of 7 years, and fine. If the crime of money laundering is involved with narcotics, the punishment can go up to 10 years. So 7 years is the maximum, but if it's drugs, it can go up to 10 years. Some definitions are given. Adjudicating authority for PMLA is defined. Appellate tribunal is defined. Attachment is defined to mean prohibition of transfer, conversion, disposition, or movement of property by an order issued. So authority might issue an order saying that now you cannot, the asset attached, you cannot, the promoter cannot transfer the asset. Beneficial owner means an individual who ultimately owns or controls the client of reporting entity. So the share might be in the driver's name, but who ultimately controls it has to be seen. Money laundering has been defined under Section 3 of Money Laundering Act. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property where such property is taken or held outside the country than the property equivalent in value held within the country. For the removal of doubts, it is clarified that the proceeds of crime include property not only derived or obtained from scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. So, explanation was added to PMLA Act to clarify that proceeds need not only include derived from the scheduled offense. So, if I did an illegal activity, got the money, and I purchased an asset. So, the proceeds of crime does not only relate to this. It can also relate to something purchased directly or indirectly by any activity related to the scheduled offense. So, it's very broad. Property means any property or assets of every description, mobile, immovable, tangible, intangible, etc. Value means fair market value. Schedule offense means offense specified in Part A, offense in Part B where value is more than 1 crore, and offense in Part C of the schedule. Section 3. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved. So see the broad contours of the definition, right? Directly or indirectly attempts to indulge knowingly assists, knowingly is a party, or actually is involved in any process concerned with the proceeds of crime, including concealment, possession, acquisition, or use, and projecting or claiming it as untainted property. So you know it's illegal, but you are claiming it as illegal, shall be guilty of the offense of money laundering. This section defines the offense of money laundering. For removal of doubts, a person shall be guilty of the offense if such person is found to have directly or indirectly attempted to indulge, knowingly assist, or knowingly is a party in one of the following activities: whether he has concealed, he has possessed, is acquired anything, is used, or is projecting illegal property as untainted property, or it is he is claiming it as untainted property. All these actions, if you are doing, you are conducting an offense of money laundering. The process or activity connected with the proceeds of crime is a continuing activity, and it continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition. So they are saying that money laundering is a continuing activity till the time the person is enjoying the proceeds of crime. Section 4 defines punishment, which obviously we read 3 to 7 years and 10 years in case of drugs. Attachment, section 5, where the director or any other officer not below the rank of deputy director authorized by the director has reasons to believe, on the basis of material in his possession, that any person is in possession of any proceeds of crime, and such proceeds are likely to be concealed, transferred, or dealt with any manner that may result in frustrating any proceedings relating to confiscation of such proceeds. So there is a possession of proceeds of crime, and it can happen that something can be done to frustrate the proceedings under PMLA Act. Then he may, by order in writing, provisionally attach such property for a period not exceeding 180 days. The officer has the power to provisionally attach for a period of 180 days. For the purpose of computing period of 180 days, period during which the proceedings under this section is stayed by High Court shall be excluded, and the further period not exceeding 30 days from the order of stay of vacation shall be counted. So period of stay will be excluded, and a further 30-day period from the date of order of vacation of stay shall be counted. No attachment should be done without a report to district magistrate under criminal procedure code. Attachment should be done, otherwise the proceeding could be frustrated. After attachment, you have to forward a copy to the authority under PMLA. Validity of order, whichever is so basically they say under order under section 8 subsection 3 or whichever is earlier, for 180 days you can provisionally attach. Nothing in this section shall prevent the person interested in the enjoyment of immovable property from such enjoyment. The director or any officer who provisionally attaches the property shall, within a period of 30 days from such attachment, file a complaint before adjudicating authority under PMLA. We are not talking about NCLT. Section 6 is the adjudicating authority under the PMLA. Central government appoints with chairperson and 2 members and adjudicating authority. Benches have to be constituted by adjudicating authority. Normally they are at Delhi, right? Only central government can remove any member from them. Adjudicating authority shall not be bound by the procedure laid down by Code of Civil Procedure, but shall be guided by principle of natural justice and shall have powers to regulate their own procedure. Just 1 second. So they can have their own procedures. Then they talk about staff, they talk about adjudication, right? Procedures, all these are basically procedures. Where the adjudicating authority decides that any property, so sorry, I'm just getting a call. Where the adjudicating authority decides under subsection 2 that any property involved in money laundering, he shall by an order in writing confirm the attachment of the property made under subsection 1. So whatever was provisionally attached, if the adjudicating authority decides that it is involved in money laundering, he shall by order confirm the attachment. What that was provisional attachment, here you have confirmation of attachment or retention of property record under section 1718 and record a finding to that effect whereupon such attachment or retention or freezing of the property shall continue during investigation not exceeding 365 days or the pendency of proceedings, shall become final after order of confiscation is passed under subsection 5 or subsection 7 or section 8 or 58B or section 60. So basically, adjudicating authority will confirm the attachment which has been made under provisional attachment, and whereupon such attachment, it shall continue, the attachment shall continue for the period of investigation, which shall not exceed 365 days. So provisional attachment you could do for 180 days, right? When the complaint is filed before adjudicating authority under PMLA, that adjudicating authority also gives an order that this attachment shall continue till the time investigation is going on, which shall not exceed 365 days. And the attachment shall become final after an order of confiscation is passed after the adjudication. For the purpose of computing 365 days, period during which stay is done by any court shall be excluded, which is very common. Where on conclusion of trial of an offence, the special court finds that the offence has been committed, it shall by order state that such property involved or which has been used shall stand confiscated to the central government. Where on conclusion of trial under this act, special court finds that the offence of money laundering has not taken place, then it shall order release such property to the person who is entitled to receive. Where a property stands confiscated to central government, the special court, in such manner as may be prescribed, may also direct the central government to restore such confiscated property or part thereof, claimant with a legitimate interest in the property or who may have suffered a quantifiable loss as a result of offence of money laundering. Meaning thereby, where money laundering offence has been decided and the property is confiscated, adjudicating authority may also direct the central government to restore it to some person who has suffered because of it, right? So we have to remember this also, because there's an interplay with IBC in this. Section 48, authorities under the act include director, deputy director, assistant director, etc. Section 63 talks about giving false information. Imprisonment is there for 2 years and fine is there for 50,000. Section 67 says no suit shall be brought in any civil court to set aside or modify any proceeding taken or order made under this act, and no prosecution or any proceeding shall lie against the government or any officer for acts done in good faith. This is very similar to your section 233. The provisions of this act shall have, section 71. The provisions of this act shall have effect notwithstanding anything inconsistent therewith in any other law for the time being in force. Section 72 talks about continuation of proceeding in the death case of insolvency or death. That property of any person has been attached and no appeal against the order has been preferred or any appeal has been preferred, and in case such person dies or is adjudicated and insolvent before preferring an appeal, or in case of B, such person dies. So in A and B, if the person dies or adjudicated as insolvent, it shall be lawful for legal representatives or official assignee to prefer an appeal to appellate tribunal to continue the appeal before the appellate tribunal in place of such person. So basically, the proceedings will continue against the legal representatives. Trial under PMLA, Section 41 and Section 67 of PMLA Act expressly bars civil court to have jurisdiction over PMLA cases. They have their own special courts. Only there they can have jurisdiction. Once may then appeal for, so PMLA has adjudicating authority as designated courts. One may then appeal above court to High Court and Supreme Court. So after PMLA court, you go to High Court and Supreme Court. Once provisional attachment order is passed by adjudicating authority confirming attachment, ED then files a prosecution complaint in the PMLA special court. The PMLA special court calls the accused, witness, etc. They do the adjudication. They examine the money laundering proceeds of crime, how the property is connected to the proceeds of crime. The prayer by ED is for attachment of property and arrest of the person involved. Then charges are framed. Police may also be investigating it. Code of Criminal Procedure does not apply. They have their own procedure. Indian Evidence Act applies in PMLA proceedings. There are powers of arrest given. Section 19 is there, PMLA Act. Possession of material, reason to believe, all these things are there for arrest. Bail is very stringent in PMLA. No one can get bail. It has to be very strict. The courts do not very easily grant bails. The court should be satisfied the person is not guilty of the offence of money laundering. Now, there is a judgment of Nikesh Shah, Honorable Apex Court judgment. So, there is a provision, Section 45(1). So, this was considered to be a very draconian provision. Section 45(1) of PMLA imposed 2 conditions for release of an accused on bail, which was held to be unconstitutional as it violated Article 14 and 21. Right? Condition required that the public prosecutor must be given an opportunity to oppose any application for release on bail, and court must be satisfied where the public prosecutor opposes the application that there are reasonable grounds for believing that the accused is not guilty of such offense, that he is not likely to commit any offense while on bail. So this is laying on the other side of public prosecutor. It's leaning on that side. So if I file a bail application, the public prosecutor must be given an opportunity to oppose me, and the court then must be satisfied based on such opposition that there are reasonable grounds that I might escape or I might do some more offenses. So it was like a draconian provision. The budget of 2018 made certain changes in the bail provision. Amendment in section 45(1) would make applicability of bail conditions uniform to all offences instead of only those offences under a schedule which are liable to imprisonment more than 3 years. So they made it consistent. Now, these are some cases of money laundering, which is not a part of our course content now, but you would have seen all these cases earlier. So I just put some snippets which you can read on later on. We had ICICI Bank case also where money was diverted to Videocon. This was also getting investigated by Enforcement Directorate. There are a lot of IPL booking cases involving money laundering. We had the Nirav Modi case which was going on. Mehul Chokshi, Nirav Modi together they have done. Okay, now we'll come to the interplay. So Section 238 of IBC talks about overriding clause, right? The provision shall be notwithstanding anything inconsistent. Section 71 of PMLA also talks about a similar thing, that the provision of PMLA shall have effect notwithstanding anything inconsistent. It's almost very, very similar. The conflict between PMLA and IBC is evident from their respective provisions. IBC aims at maximizing value of assets, revival of the company, running as a going concern. PMLA, acting as a loggerhead, provides for confiscation of assets arising from money laundering. So one place you have value maximization going concern. In other case, you have confiscation of assets. This is a major hindrance for valuation and CRP. The factor of inconsistency assumes importance in deciding if the provisions of the code will prevail. Only if the provisions were to be rendered inconsistent with provisions of another law, it will have overriding effect. Apex Code, while delivering the judgment of innovative industries, reiterated principles laid down in numerous judgments and emphasized that inconsistencies shall be clear, direct, and irreconcilable. Furthermore, the contradiction should be severe so that the legislations tend to be in direct collusion with one another. There should be a direct collusion of the provisions, making it difficult to follow them both at the same time. The current situation, a successful resolution claimant cannot handle the corporate data affair as a going concern without control of property. If I'm an RP, how do I run the company if the assets are confiscated by PMLA authorities? However, PMLA on the other hand sets down under Section 5 to provisionally attach the property. So both the laws have conflicting provisions. Section 18 of the IBC says RP has to take control of the assets of the company. The duty and managing operating affairs are also with the RP. But now this asset is attached by the Enforcement Directorate. So to obtain custody, I'll have to deal with the Enforcement Directorate. In addition to this, as per Section 14, there is a moratorium. Suits proceedings against the company, including anything is prohibited. But PMLA will be doing its proceeding even when moratorium is happening. So there is a landmark judgment, Solidaire India Limited versus Fairgrowth Financial Services. Honorable Supreme Court held that the legislation enacted later should prevail over the former, as the later law was well aware of the earlier legislation and its non-obstante provision at the time it was enacted. So you have non-obstante clause in IBC, you have in PMLA. PMLA came in earlier, IBC came in later. So the Supreme Court said the latter judgment should be used. Latter law should be given prevalence. This rationale can also be viewed by referring to the Latin maxim, leges posteriores prius contrarius abrogantem, states that if two special statutes contain non-obstante clauses, the non-obstante clause in the later special legislation shall take precedence. Similarly, in the present case, it can be seen that both legislations, PMLA, IBC, contain a non-obstante clause in Section 71 of PMLA, 238 of IBC. Hence, the issue comes to a logical end with the IBC overriding PMLA. The Solidaire judgment of Apex Court was followed in the context of court having overriding effect by NCLT Kolkata bench in Surendra Kumar Joshi versus RA Agro. In this case, NCLT followed the solitaire case of Apex Code, that the code has an overriding effect over other statutes. It was also done in Raman Ispat case by NCLT Allahabad. NCLT Bombay Industry Infra Finance versus Sterling SEG, referring to decisions of NCLAT in Punjab National Bank versus Deputy Directorate Raipur and Bank of India Deputy Director of Enforcement Mumbai, concluded. So NCLAT, as NCLT Bombay, referring to judgments of NCLAT, has concluded that the adjudicating authority and PMLA could not continue to keep the property attached after the declaration of moratorium to the applicability of Section 238 of the IBC. So it's Section 238, IBC is overrides PMLA. Section 14 is there. Adjudicating authority under PMLA cannot continue the attachment when moratorium is on under IBC. Honorable Justice Manmohan Singh, speaking for the appellate tribunal in both the above cases, in the NCLAT cases, has held the non-obstante clause in IBC, which is a latter statute, shall prevail over the non-obstante clause in Section 71 of PMLA. This jurisprudence showcases the shared intent of legislatures as well as the BLRC that the IBC code will override anything containing any other legislation effect at that time. Ultimate beneficiaries under PMLA and IBC are the secured creditors or financial institutions who have filed the claim. Because in PMLA also, from the realization made from the property, it is again given to the banks only, right? In fact, Justice Manmohan, whose line we just read was in a very recent function, he was telling the same thing, that attachments are done by authorities. And when I asked them what are they going to do with it, they said we'll set it and we'll give the money to the lenders. In IBC is also same, but they will follow PMLA law only, right? They will not come into the IBC. So although the object is same, different prosecution is happening. So then this can be noted by referring to Section 31 of IBC, which provides for a resolution plan aimed at expediting insolvency process and to secure maximization of value of assets for distribution of all. Section 8 of PMLA code, where special court under PMLA, we read Section 8, where I said that the court might direct central government that confiscated property should be handed over to an agreed person or a suffered person. So Section 31, you get the revival plan, resolution plan, it gets settled to all the creditors. Section 8 of PMLA also allows this flexibility that the government is directed to give the assets back to the suffered persons like the creditors. The IBC offers the timeline which resolution must be reached. Apart from enforcing punishment, the object of PMLA is to recover property and compensate affected parties by confiscating and selling the wrongdoer's property. Considering the economic interest of beneficiaries, IBC will provide an earlier solution to the issue at hand. NCLT in stray case and compared that to the time process of IBC, criminal proceedings in PMLA will take longer time. So IBC should prevail. Appellate Tribunal for PMLA, Appellate Tribunal for PMLA in Punjab National Bank versus Director of Enforcement Raipur reiterated the same, stated that the trial of criminal case brought against the borrowers often takes several years, putting creditors at disadvantage. So PMLA appellate also held this, that this might take a long time, so maybe IBC should be given the way. Now you have Delhi High Court judgment of Deputy Director of Enforcement Delhi versus Axis Bank. This came out in April 2019, pre-Section 32A. Section 32A protects corporate debtor and resolution applicant from past non-compliances. So this was brought in pre-Section 32A. Allowing the overlapping of IBC over the provisions of PMLA would lead to misuse of an application under moratorium as an escape route by offenders. Honorable High Court of Delhi claimed that the implementation of moratorium would result in a situation in which criminals could use the code as an escape path. In this case, Honorable Court held that a person who committed the crime could not use the proceeds of crime to repay his debts to his creditors. So proceeds of crime cannot be used to repay creditors. If same thing is allowed to happen, the properties that do not legitimately belong to him can be used to discharge a civil legal liability, which cannot be allowed. In Vasna Ispat versus Deputy Directorate, May 2019, analyzing the scope of Section 14, Tribunal stated in paragraph 13 that it will be applicable to the individual, which may include the ex-director and shareholder of the corporate debtor, and they cannot be given protection under Section 14. Section 14 is for assets of the company, not for the promoters. So promoters, PMLA can go against the promoters. It is a well-settled principle of law that restricted meaning should be given notwithstanding or non-obstante clauses in order to ensure both statutes are interpreted harmoniously. Such an interpretation is consistent with the presumption that there is no repeal by implication. Basically, if harmonious interpretation is possible, you should do that. According to the doctrine of harmonious interpretation, even though if it's difficult to resolve the discrepancies or clashes between two provisions, the court may view them in such a manner that all provisions or statutes are given as much effect as possible. The words of Justice Krishna Iyer, legislative futility is to be ruled out as long as interpretative possibility permits, right? Something is made in law, it is made with some mind, right? Legislative futility should be ruled out with interpretative possibility. So there is harmonious interpretation possible. You have to do that. Apex Court in the case of Raj Krishna Bose, Vinod Kumar Kanungo stated that legislature's purpose cannot be to render one clause or bit of legislation ineffective. When you come up with a new act, your intent is not to make something earlier act of ineffective. Hence, it would be possible by harmoniously interpreting two statutes to give effect to objectives of both laws. You should do that. Same can be noted from this Delhi High Court Access judgment, where the court, while deciding upon issue of overlapping effect, took a harmonious interpretation. High Court emphasized that the need for holding two provisions as providing other statutes with overriding power would negate the object of PMLA. So if you say IBC overrides PMLA does not exist, then there is no point of PMLA and defeat the entire purpose of PMLA enactment. Therefore, since the authorities concerned are distinct, there would be no overlap. And therefore, all claims can be filed concurrently until the resolution applicant invests its money in the restructuring. This will give all provisions a reasonable chance to achieve their goals. In light of the same, it is suggested that a balance must be reached between the two provisions, and this can only be achieved if all legislations are considered when making decision on the same. So High Court said you have to achieve a balance between both. Then you had an NCLAT judgment, Directorate of Enforcement versus Sri Manoj Kumar Agarwal. NCLAT in Manoj Kumar Agarwal was considering correctness of two orders passed by NCLT. And by these orders, NCLT had directed ED to release attachment on the assets of two group companies and hand over to RP. So NCLAT was, looking into these two queries. So these are the timelines basically. So there was a provisional attachment passed on 29 May 2018 by ED, PMLA court. Then NCLT Mumbai admitted CARP petition in July 2018. So provisional attachment happened, then CARP got initiated. RP intimated ED about the commencement of CARP. Adjudicating under authority under PMLA confirmed provisional attachment under Section 8 in November 2018. Okay. NCLAT upheld the orders of NCLT, which ordered for detachment, and NCLAT held that NCLAT rejected ED's contention that NCLT Mumbai did not have jurisdiction to interfere with the attachment order, and the RP should have approached the adjudicating authority under the PMLA. So ED said RP should have come to PMLA court. And NCLT does not have jurisdiction. NCLAT rejected that. Any hindrance created by attachment or taking over of the possession of property would be a question of priority arising out of or in relation to CRP or liquidation proceeding, which can be decided under Section 60, subsection 5, clause C of the IBC. After the provisional attachment of property under Section 5, when the matter goes before adjudicating authority under PMLA for confirmation, such proceedings would be civil in nature. If CARP has commenced institution and continuation of such proceedings before the adjudicating authority under PMLA would be barred by Section 14. So NCLAT says this attachment confirmation is civil in nature, and Section 14 bars all civil actions. While recognizing that both IBC and PMLA are special statutes, the NCLAT held that IBC enacted later in time will override PMLA by virtue of Section 238. Authorities under PMLA cannot resist handing over the attached properties of the company to the RP, and by this going concern will be affected. NCLAT clarified that the attachment made under PMLA will remain in force in two scenarios. One, when the application admitted is withdrawn under Section 12A. Second, the order of admission is set aside in appeal. So if admission is set aside or withdrawn, then attachment will continue. NCLAT took note of various steps which are required to be taken during CRP for maximizing value. NCLAT also took note of Section 232A, which was enacted when the orders were being passed. It provides immunity against prosecution for past non-compliances. NCLAT accepted the contention of ED that 32A is not helpful in the present matter as it did not reach the state of acceptance of plan. Although 32A was not relevant here, NCLAT still referred to it. So this decision was a huge change in the jurisprudence because NCLAT said that NCLT has jurisdiction and you should hand over the assets back to the RP. This decision gives right to IBC, primacy to IBC over PMLA. Under PMLA, properties are attached. They are required to be confirmed by PMLA authority, and a determination is required to be made during a trial whether an offense of money laundering has been committed and if they are proceeds of crime. So in IBC, I have to take control of the asset, whether it's got out of proceeds of crime or what. I am not aware as an RP. My duty is to read the balance sheet. Whatever assets is coming on the balance sheet, I'll have to take custody of that. Then you have Nitin Jain, liquidator PSL versus enforcement director case, again, Delhi High Court. Here, CRP was initiated by the company in 2019, February. Petitioner was appointed as the liquidator. Nitin Jain, liquidator, was appointed. And upon expiry of mandated time for proposal plan, liquidation was instructed and application was made. After approval of the liquidation application, sale notice was issued by liquidator, which was not met with by summons. So he issued a sale notice under liquidation regulation. During this time, liquidator was called on by enforcement directorate for the first time. CRP over, liquidation started, sale notice issued. ED is calling the liquidator in January 2021. Subsequently, an offer for sale of corporate debtor was made, which was approved. So one bidder came, he gave an offer, which was approved by the adjudicating authority, NCLT. It was provided that the distribution would abide by Section 53. When matter came for hearing before Delhi High Court, ED had not passed a provisional attachment order for properties of corporate debtor. So till this time, ED had not even given a provisional attachment order. The primary contention that came up for consideration was whether the scheme of liquidation would get inhibited by the statutory process for attachment of property under PMLA. I have done a sale under liquidation regulation and provisional attachment is not made by ED. Matter has come to High Court. High Court has to see whether whatever is getting done as going concern sale, will it inhibit the process of attachment under PMLA? The liquidator contended that there's a Section 32A and there is a Supreme Court judgment. Relying on Section 238, liquidation must be exclusively governed under provisions of IBC. ED contended that this ED's objective is to follow proceeds of crime. Confiscation of property falls under jurisdiction of PMLA. It also contended that IBC cannot be an amnesty route to escape statutory mandate of PMLA. Promoters cannot use, so if you allow this, tomorrow promoters will try to use this to escape PMLA. Any sale under IBC would defeat the basic objective of PMLA since both the statutes operate in separate and distinct fields. The contention made is both are separate. The code and PMLA are separate. It is further contended that the proceeds against the properties are autonomous. A resolution process under IBC is contradiction with the liquidation process under Chapter 3. They are saying that don't apply case laws where IBC in resolution overrides PMLA. This is a case of liquidation. So they are saying resolution process under IBC is in contradiction with the liquidation process under IBC. Process under Chapter 2, which is resolution, as a different track which attracts 32A. Section 32A can be referred for resolution, not for liquidation. Does not hold its application under Chapter 3, which is for liquidation. Delhi High Court analyzed the schemes. They say both the statutes are special statutes. IBC is enacted to restructure the companies. PMLA focus on punishing crime of money laundering. Objectives are clearly provided, but there is no reason for both the statutes to not coexist. Court held that while the order of liquidation had already been made by adjudicating authority, NCLT, there was no reason for the petitioner herein, the liquidator, to not cooperate with the process being followed by ED. The court basically says that when liquidation has been accepted by NCLT, liquidation process is going on, you can cooperate with the enforcement director officer, give them whatever information you have, whatever you can give, right? So a very balanced approach or harmonious interpretation was tried to be taken here. So as on date, if you ask, we have currently some cases where enforcement directorate has attached the assets of the company. As an RP, the first step we do is to first find what assets are attached by different authorities. We write to the stakeholders that we understand that this is attached. Moratorium has started. I am appointed to take custody and control. So kindly hand over the custody to me. And you can have two approaches here. There might be cases where you can go to the designated court under the PMLA Act. For example, MPID Act, also Maharashtra Protection of Investor Deposit Act, they also have designated court. There are case laws on MPID Act and IBC as well. Okay, so you can go to the designated court and plead there, saying that moratorium is there, don't proceed to realize any asset. You can get success there. You can't really short, you can't say it. Or you can say that this is a question arising out of insolvency because I have taken over as RP. I am bound to take custody of assets. custody is not being obtained from the enforcement directorate. It's a question of law. I'll approach NCLT under section 60, subsection 5, clause C. We have NCLAT judgment with us. We can use that judgment and to get order from NCLT. So practical challenges will arise. You will get a order from NCLAT. They might go to the High Court. All these things has to be put an end to by a legislative amendment or probably a Supreme Court judgment. And PMLA judgment is still pending before Honorable Apex Court. It's still not decided. If once that comes, we'll have more idea. Right now, for corporate governance measures and objective of court, we should intimate the authorities to deattach the asset. And if that intimation is not working, we should definitely approach NCLT or the designated court, at least to show that our action, our efforts to getting the deattachment done. If you don't do that, you cannot have an information memorandum properly prepared. You cannot do evaluation, right? You'll not be able to even conduct the CARP. If you don't have assets, who will come and bid or give a resolution plan for the CARP? So this is the state as on date for PMLA. Any questions on this? You might feel free to ask, because I'm going to conclude the session as well. Any questions on PMLA?
So, sir, what is the present situation clearly? What can we assume in the where the PMLA is involved or ED is involved?
I just told you, sir. So first step is RP has to write to the authorities. First, you get the information from promoter, what assets are attached, and you write to the authorities that I am appointed as RP, so and so NCLT order, admission order, moratorium is there in place, section 14 is there. Kindly deattach the asset and hand over the custody to me. That's the first step you have to do. Okay. If you don't get a response, you have to approach NCLT or the designated court under PMLA or MPAD, because they might go and realize the asset. They might just say that proceeding is underway. They will realize the asset. So you have to move an application immediately to the designated court or the NCLT and get an order, so that you can show that you have done your effort. The PMLA question is pending before the Supreme Court. That has yet to be decided, and no amendment has been done in the court. This is what we are following practically.
Right, until unless Supreme Court clears the cloud over that.
Yeah.
Either
That's
NCLT
there.
and
Even you can look at yes, you can look at MPID cases also. That's also like very interesting. There also you have designated court, and that is for protection of depositors. Basically, if there is a default, like the NSCL scam was there in 2013, and there was a large default, 5,000 crore scam was there, and the depositors suffered. So MPID case was invoked there. Maharashtra Protection of Interest of Depositors Act, right? There also you have designated court. In there also you have IBC cases where courts have said you approach the designated court, and some cases NCLT and CLAT has taken the jurisdiction and passed an order. So there is a mixed match of orders here.
yes, that is the problem. Things are not clear actually until unless the apex court clears the cloud.
Yes, we have to do duty as RP to at least take our efforts. Then we can leave it to the COC. Yeah.
Thank you, sir. Thank you so much.
So we had a broad look at the contours of IBC, how it touches with different provisions of law, and what interesting judgments are there in Limitation Act, in PMLA Act, right? I've also showed you judgments which have overriding effect of IBC, like Innovative and Ghanshyam Mishra judgment. So from RP's perspective, first understand the legal framework which is applicable to any entity, then understand the deficiencies which are to be complied by you, understand what challenges can come in your CARP process by way of attachment or seizure or bank account freezing, right? And then take suitable steps at relevant forums like NCLT or the designated court to put in your effort, document that effort, minute it, even convey to the COC. So tomorrow it does not come on the RP that, what did you do? If there is no asset, how could you prepare information memorandum? Resolution applicant should not come and say that you misrepresented in the information memorandum. So put proper disclaimers. Also, the very good point raised by one gentleman here on the claims part. If somebody is filing a claim which is time barred, not many will look at this aspect, right? It should be looked at it. If somebody is filing a claim barred debt, you have to take legal advice whether to admit it or not. because when the debt itself is not due and payable by way of it being time barred, where is the question of admitting it, right? Obviously, if you reject it, somebody might move NCLT. NCLT gives a direction, we will follow it. So that's the broad discussion we had on the interplay. I hope I could give some insights on it, share some insights on it. That's my number and email ID. Anytime, any query or anything like to speak on, can feel free to reach out. That's it from my end. Any other queries, please, you can ask. We'll conclude the session.
So nowadays, the claim, belated claim for belated claims, RP has been entrusted with the responsibility to
Yes.
NCLT.
Not NCLT, sir. There's an amendment in regulation. So
Yes.
typically, you give 14 days from Form A for filing claims. Then
Yes.
regulation also says till 90 days from insolvency commencement date. As
Yes.
per court orders, you could submit claim till approval of resolution plan by COC. Now there is amendment in regulation as well, which says that before resolution plan approval, if you have claims which have come, you have to prepare a list, and what could be admitted, what could not be admitted, and you have to place it before the COC, and then take a call. And that information has to be given to the resolution applicant also. This amendment has come in CRP regulation.
Yes.
Yeah.
Right, sir. Thank you.
Thank you, sir. Anybody else? Any other queries? I think that we can conclude the session. I hope I could share some interesting cases. Thank you all for all your patient listening.
Yes, it was very knowledgeable session.
Thank you, Deepak ji. Thank you.
Thank you very much, sir. I
Thank you.
extend my sincere thanks to you for taking out time and addressing session on the workshop on Limitation Act with IBC. Thank you for sharing your experience and views on the topic. And I request you to kindly share your PPTs also.
I'll share.